Good morning, everyone. Welcome to Research Skills Series number 3 for the academic semester 1. Today, we have two of my colleagues who I met at King's College London when we were all doing our PhDs, and I had the honor of graduating with them. We got to cross the stage in person very recently after having some COVID delays, so it was great to see them in person. And I took that opportunity to ask them to come here and share their knowledge with us. So we have Dr. Knöpfel and Dr. Reheem, who will be talking about transnational law. Now, these two started their PhDs at King's College London right after they formed the Institute researching transnational law. So we really have two experts who have gone through very in-depth process of research who will be sharing with us today. They will be speaking about researching transnational law in the local context, what questions to ask, what methods to use, and how can we study transnational law. So whether you have never heard of transnational law before or you are researching but you're looking for more guidance, this is the right place for you. So I'm going to hand it over. Apologies, I'm going to hand it over to our two speakers today. Please keep your questions to the end of the presentation, but there will be an interactive element of the presentation and they will direct you accordingly. So Laura and Sapna, over to you both.
Thank you so much, Emma. It was so nice to see you virtually, and also Justin to hear you virtually as well. And Laura, it's so great to see you virtually too. So good evening from where I am. I'm currently in Italy, and Laura is on the border of Italy and Albania. And we are excited to talk to you through some of the research dilemmas and research issues that we faced while studying this phenomenon of transnational law in local context. And as you would see through our presentation, you would see that like Laura and I, start from very distinct starting points with regards to transnational law. And we hope that we can explain to you why we started from those points, and we can also hopefully discuss with you some of the concerns we had and some of the debates we continue to have regarding transnational law and the methods for studying transnational law.
Good morning, good evening also from my side. It's a pleasure to be here and to share a bit or to discuss a bit about what transnational law is and how we can study transnational law in the next couple of minutes, in the next hour. We thought that before being able to talk about how to study transnational law, we need to spend a bit of time to speak about what is transnational law as such. And this is in itself a tricky question, because transnational law is not just a thing that is out there and then we can pick and choose what you want to study of that thing. But transnational law is something that needs to be defined in defining a research project or in researching something that could be called transnational law. And since this is one of our discussion points, the discussion point between Sapna and myself, I don't think that we use the same conception or definition of transnational law. And this is why we thought we'd just start with a couple of minutes defining transnational law or looking at different perspectives on what transnational law could be and how we both understood transnational law in our respective researches. Then after having done this, we're going to delve into the questions that were put to us by Emma. How do we study transnational law? What questions can we ask about transnational law? So what questions are typically asked in transnational legal projects? And then spend a couple of very practical minutes on what methods to use to study transnational law, which methodological frameworks are there that help you to define a transnational legal project and guide you through the questions, through the methods, through the actual methodology in order to study this phenomenon, which is now called transnational law, which we call transnational law. And then to end, we thought it could be interesting to just give you a bit of insights into our respective research projects. Sapna will start with her PhD project on judicial reforms in East Timor. She spent quite some time in East Timor studying judicial reform processes, and she will talk about this from this methodological point of view of transnational law. And then I will end with my own research, which was on corporate social responsibilities law in coal mining in Colombia.
Okay, so as Laura said, this defining transnational law or chasing definitions of transnational law is quite confusing or ambiguous within the literature. And you see that different scholars have different ideas of transnational law. So that is why we put this image of the 7 blind men and the elephant. And I'm sure that many of you would be aware of the story of the blind men trying to understand what an elephant is and touching different parts of the elephant and saying that, no, it's a rope, it's a snake, it's a tree, so on and so forth. So similar to that, I'm not saying that the scholars are all blind men or women, but similar to that, we see scholars building on specific traditions or specific bodies of literature or areas and trying to define what transnational law is. So one way that we see that the literature or some of the scholars look at the idea of transnational law is this building from international relations scholarship and sociology scholarship, as well as world polity and law and development scholarship, and looking at law as a social regulation tool for people who believe in this idea of internationalism. And then we see other set of scholars who are mainly trained in the area of law, and they argue about transnational law as a distinct field of law, which is similar to international law or international criminal law, but distinguished from those fields as areas such as international trade law or intellectual property law, or even now the emerging field of climate change regulations, so on and so forth.
And then third, the very notion of the term of transnational law goes back to a US American judge who defined this notion of transnational law in the 70s. And he wasn't, at that moment when he defined it, he didn't act as an academic, but he was a judge. And he observed that he had cases on his table which involved cross-border problems. And to those problems, he just, in his opinion, in his view, he just couldn't find the legal solutions in national law or international law. And so he thought there needs to be a new concept, a new notion, a new field of law from which he could draw, or different judges could draw rules to solve these legal problems. So in a way, the beginning of the notion of transnational law was a very practical one. It was one to solve very practical border transcending problems. And this is why he then defined transnational law in an extremely open way. So transnational law in his writings could be hard rules, hard national rules, but it could also be social norms that define conduct of actor that somehow have a border, crossing a border transcending element in it. And then lastly, from this idea of having this openness to what could be defined as law, a method resulted from this field of transnational law. And those are the scholars that look at transnational law, that understand transnational law as a methodological framework, as a framework that gives you a direction on how to study legal phenomena within transnational processes, within border transcending processes. And this is then not to say there is a norm that is transnational law, there's a field that is transnational law, but more this is a lens that we can put on in order to study legal phenomena in the interconnected world that we currently living in.
So as we would be going to unpack our own doctoral research, you would notice that I start off with this idea of transnational law as a social regulation tool for internationalists or people who believe in an international law project. And Laura's project, or Laura's starting point, is more of a methodological perspective, where she observes transnational law as this methodological lens to look at specific processes and specific phenomenon in local context. And if you have any questions specifically with regards to it, we are more than happy to take it during the discussion time. But although we have highlighted the fragmented nature of the definitions from different scholars, we wanted to highlight to you some of the common strands or common understandings or agreement between different scholars on this phenomenon of transnationalism or transnational law. So they all agree that there is a movement of ideas, institutional arrangements, as well as understandings of certain standards across nation borders. So there's a blurring of this nation and the international borders, as we can say it. And they also agree that there's a movement of people and institutional structures like the international NGOs, which have local branches, as well as international multilateral organizations such as the UN and the EU, which have their own branch offices, that have facilitated the movement of these ideas and norms and standards across different nation borders. Some of you might observe that these sort of mobility of ideas and standards have always traveled across different cultures, because if you look at historical texts from 12th century onwards, we can see that merchants and traders have always carried ideas of commercial law and commercial principles across different borders. But what we see with this new age, or our current contemporary age, is that with the increase in communication network, with the increase in the number of international organizations, we see a much more large intensity of cross-border interactions between internationals and the locals. And the other way to look at it is the emergence of global multinational corporations, with the idea that they will produce the same sort of products according to the same sort of standards. Of course, we can contest whether the standards and the quality and whether these multinational corporations do comply with it in different parts of the world. But it also goes, but to come to the core of it, it also goes to this idea that irrespective of wherever you are in the world, you would be guaranteed a same standard, be it in the justice sector, be it in commercial be it in the commercial transactions, or be it in terms of any sort of private interactions that you do with a business enterprise. So here we have a component where we would like you to engage with us and tell us as to what does law mean to you in the transnational context. I hope you can see my PolyV text notification. Laura, can you see it? So do you see text Sapna Reheem to 22333? No? You can't. Can someone let me know, because I can't.
So we're seeing a picture on the left, but we're not seeing anything on the right.
Ah, okay. So Laura, this is similar to what you were saying as well. So why don't we just skip this, and maybe you can use your chat box to let us know, how do you conceptualize law in the context of transnational law, or in the context of a transnational world?
All right, so I've just typed in the text box so everyone can see what it is. You can type your responses there. So Sapna, do you want to just repeat the question one more time, please?
Yes, so what does law mean to you in the transnational context?
Great, so that's the question. It's also on the screen, so everyone can use the chat function and you can type your responses, please.
Well, we don't have anyone chipping in. It's
Well, I just put in an adjective describing what law did to when I started my PhD, what it meant to me, and I think to me the noun that described it the best was just messiness. To me, law in a transnational context, the context I wanted to look at, was just a whole mess. You had different standards, rules, norms, laws, regulations on different levels of regulations, different actors engaging with it. And I just, in the very beginning of my PhD, I always described it as something that is very messy.
So Deborah has something similar there as well, something where she says a law is something which is applicable or in effect across several jurisdictions. So this goes to this idea of, you have regulatory framework that you can enforce across different jurisdictions. And Justin's intervention is that similar to Jessup, he observes that it's a hole between domestic and international law. So it's that vacuum or the messiness that Laura seems to suggest, because it could be anything and it could be also this hole or the absence between domestic and international law. And Grace, you have here law in the transnational context is quite complicated since it transcends across borders, and there are various laws, rules, perspectives, morals, etc., that vary across jurisdictions, perspectives, etc. So, Grace, I can see that you're bringing in this idea of legal pluralism. So, you are kind of suggesting the difficulty or the messiness, as Laura was mentioning about, can we even define law within the other context? And Deborah, yes, that's a very good example of Singapore, the Singapore Convention, and I'm assuming that you were meaning the International Arbitration Convention, so on and so forth. Okay, so I'm going to move from here, and we can take more of these discussions during the discussion time. Oops. I can't seem to move my slide. Okay, so within the literature as well, we see different starting points of law within this area of transnational law. So some people look at law as codified legal instruments in cases. So this is similar to what Deborah was suggesting when she was mentioning the Singapore Convention. And here you have scholars who are predominantly international criminal lawyers or international law lawyers who look at how these international principles work in an international context or a local context. So some of the examples are Sarah Nguyen, who has worked on this idea of a customary international criminal law principle called as the complementarity principle, and how it works out in contexts such as Uganda and Sudan. And Nikki Palmer looks at transitional justice principles and international criminal court ideas in the context of a country emerging out of war as well. Mikkel Christensen, who is an international criminal lawyer who is based at the I courts in the University of Copenhagen, he recently has got a project grant to look at the global sites of international criminal justice. So again, looking at very clear, distinct codified legal instruments and cases and how it operates within local context or in international context. Then we see scholars, mainly from anthropology and sociology and international relations, and sometimes lawyers who do interdisciplinary work, who look at law more as soft law, such as codes, regulations, and rules that emerge from multinational corporations or international organizations, just such as the World Bank, the IMF, those sorts of organizations. And some examples that you have here are Sally Merry, whose work on the construction of gender violence, Convention Against Violence Against Women, is a very famous book where she maps how this convention comes about at the international level. And she also writes about how this convention was translated into the local context, such as in Fiji and in India and in other parts of the world. Then you see a different set of scholars, and here within this category, here the scholars look at practices that are emerging from social groups and communities, regulating norms and behaviors of people beyond borders. And within this group, you see anthropologists, sociologists, political scientists, not many lawyers, but the kind of questions that they ask are questions regarding how social media communities are influencing norms and standards regarding protection of women in workspace. So some interdisciplinary legal scholars have written on the Me Too movement. So that is one area we see the lawyers looking at these practices emerging from social groups. But amongst IR scholars and political scientists, we see a bit more diverse set of literature emerging. Literature on the Sharia law being transferred to different parts of the world, to Islamic communities, or Lee and Murdy's recent work on Me Too movement and the global diffusion of Me Too movement as a standard through social media platforms. Paul's work is also on religious norm and diffusion of religious norms. And we have some exciting work coming up on conspiracies, which again, lawyers have not entered into that field. So it's mostly people from other fields who look at these aspects.
So after this brief introduction to the variety of what transnational law is currently in scholarship, we're now going to look at how to study transnational law, how to study transnational legal processes. Obviously, as the area of what transnational law is so diverse, also there exist different starting points. The first starting point, as lawyers, this is quite an obvious starting point, is the law itself. So taking a specific domestic regulation, for example, and looking at it from the lens of this transnationalism. So how a norm travels, for example, and this is what Sapna talked about this with Sally Mary and her work on gender violence. For example, she looked at how the UN treaty against for the protection of women against gender violence, how those norms enshrined in the international treaty traveled or was dispersed into different domestic settings. And this brings us to the second starting point, which is not the law itself, which is maybe a more lawyerly perspective to look at it, but to look at the context of the law. The context of the law could mean where the law is applied, by whom it is applied, but the context of the law could also, for example, be, and this brings us to the third starting point, could be to look at the context of the making of the law. So who was responsible in drafting a new norm? Who is behind a specific law? Who is behind a traveling of the norm? Like why do different jurisdictions, different countries suddenly adopt very similar laws to a problem that faces all of us? And I think a very practical example that we saw recently, where the different rules adopted, the different laws adopted in response to the COVID-19 crisis that affected virtually all countries of the world, and looking at where do the differences lie, what are the similarities, which are the different responses of the countries, and looking at it through the perspective of that it was a virus that affected all of us. And this already brings us to the last 2 points on how to study transnational law, which starting points to choose, which are, for example, the actors. So, for example, one could follow an international actor. This could be a natural person, but it could also be an institution and an organization, or one could study the sides of the law. And again, the sides of the law could mean the local application of it, the national application of it, but also the developing of the law and the traveling of the law through local, regional, international sites.
So we thought that, all those sort of points might make it look like a very amorphous way of saying that these are the ways to study transnational law. So we thought of maybe providing you some examples from the literature itself. Of course, these examples are non-exhaustive, so please keep that in mind. So one of the ways that you can think about what kind of questions could you ask as a researcher who wants to study transnational legal phenomenon in a local context is to maybe look at norms at the international stage. So as a researcher, you might want to ask questions as to how are these international norms being constructed at the international stage. An example for that is Radha Ivory has written recently on how the construction of anti-corruption norms came about at the international level. And she traces the influence of certain lawyers from specific jurisdictions such as Australia and America influencing the construction of this international normative standard on anti-corruption. Or you could be looking at these norm construction within the national context, where you might want to ask questions as to what happens when these international norms are taken to the national settings. So in that way, you might want to ask questions such as, how does the international intellectual property standards might apply in the context of Trinidad? Or you might want to ask questions as to what are the challenges that occurs when lawyers, IP lawyers in that local setting have to translate these international standards to the needs of the local population. Some of you might want to start with actors, as Laura mentioned, so you might be interested more to know about who are the groups of people who are involved in the process of the construction of these norms at the international level, or translation of these norms at the national or the local levels. So you might have different questions accordingly as well. Or you might want to ask questions on normative arrangements as to what sort of institutional arrangements are necessary for the construction of an international normative standard. And we see a lot of environmental law scholars now debating on the institutional arrangements for trying to regulate kind of climate change and regulate action, as well as to ensure that states do take on responsibility to fight against climate change. We also see scholars working on what sort of institutional arrangements are necessary for regulating waste in different parts of the world, and how do you ensure that you make other states accountable if they are not following these rules, so on and so forth. So that's more of a normative question. Or you could ask very critical questions as well, as Matthew Canfield and Julia Dem and Fassi, they do in their 2021 piece, where they look at the power dynamics that emerge as a result of interaction between the internationals and the locals when they come in contact at the national level or at the local level or at the international level. So you could very well do such sort of research within the umbrella of transnational law.
So you have noticed that transnational law, I would say in the majority of scholarship, is not a black letter approach to law. It's not a doctrinal study of law, but it's a field that was born from this practical concern with transnationalism, with border transcending phenomena. And as such, it is a field that is looking for social legal methods to study law in context. And this is that there exist some methodological frameworks that give you some guidance on how to go about studying such phenomenon. I would say the umbrella frameworks, the umbrella fields of scholarships are social legal studies and law and society. Social legal studies is more the term used in Europe and in countries with scholars that work in were formed in a European transition on thinking about law in context, law plus another discipline, and then law and society. This notion of law and society is more a US American notion on thinking about social legal studies. That's my reading. And then with law and society, the question I always have is, well, isn't law part of society? So what does this mean to put law and society on the same footing? But this is also the name of the official association of social legal scholars in the US, which is called Law and Society Association. And then within those umbrella fields, you have legal anthropology and legal sociology. These are, from the perspective of law, these two disciplines are part of social legal studies or law and society. And they both come either from the tradition more of anthropology and more of sociology. Obviously, those fields are not that clearly separated today, but they give you some direction on which methods to use, which questions to ask, which should be the outcome or the result of the research. And then more coming from within law itself is transnational law as such, as a research methodological framework, and new legal realism, which is the most recent intervention in the transnational law scholarship. And we put those two terms very, better said, Sapna puts those two terms in red because she doesn't really agree with qualifying transnational law and new legal realism as methodological frameworks. But to read transnational law as a methodological framework, and this was defined as such very influentially by Per Zumbansen, who brought transnational law from a US setting into a European context. He said, well, the best way to study transnational law, to study processes, legal processes that transcend national borders, is to look at the actors, at the norms and the processes. And here within that triad of notions, so actors, norms, processes, you notice there's no law in it. It doesn't say actors, law, processes, it says norms and processes. And this already sheds light on the fact that what is at interest here isn't just black letter law, but all the norms that somehow define transnational behavior, transnational conduct of different actors. This is why actors. And then with processes, looking more at the process of translation, for example, rather than just at the case as a result of a social conflict. So more an interest into the processes that lead in the end to solving of a social conflict. And then from this idea of transnational law, new legal realism emerged recently as a methodological framework, I would say. New legal realism, new because it goes back to the legal realism of early 20th century in the US. So having a particular focus on the impact of judicial decisions of new laws on society, so on social relationships, on social context, and studying those impacts with methods. We talk about this in a bit, with methods chosen from other disciplines, such as, for example, anthropology, sociology, political science, or from economists. And then what is new, and this is why new legal realist scholars, they don't stop there. They don't just look at the relationship between a new law and society and that impact relationship, but they try to reflect it back into law. So they try to ask, well, when we know how it's applied in society, when we know about the effects in society, what does that then tell us about the law itself, and how could that be reflected into legal processes itself? And this is, I'd say, the most recent methodological intervention within transnational law. This already brings us to the methods on how to study transnational law. As we said, it's not transnational law in most parts. I mean, there are some black letter law scholars within transnational law, but most scholars are interested in societal impacts of laws. And this brings us into other discipline, because law as a discipline is not an empirical, I'd say it's not an empirical field of research. It's not an empirical field of thought. It's interested into normative questions, into text, into doctrinal solutions to legal problems. But transnational legal scholars, they pick and choose a bit research methodologies and methods from other disciplines. So, for example, when you have a background or when you're an interest in political science, you might want to analyze quantitative data sets with statistical analysis. So a research question that could be asked when coming from that perspective or from that background is what influences people's compliance with legal regulations? And this is a question that you find in different research questionnaires in different countries. So you can run a statistical analysis, and then you will have there will be a causation effect between two different variables, and then you have an answer to that question. But when you're more coming from anthropology or sociology, those are the scholars that conduct long interviews with people, with different actors, and these are not just judges or people in parliament that draft new laws, but these could also be people from local groups that are the target or the subject of new legal regulations, and talking to them about how they see a different law or a different norm. With a background in anthropology, this is where I'm coming from. There's a lot of very long-term participant observation on how a law, for example, changes a social relationship. This is fieldwork. This is immersing yourself within the context that you want to study. And then with background in history, this is the research that then goes into archives, looks at historical documents in order, for example, to trace the emergence of a transnational legal norm.
Okay, so that brings us to our own case studies. I'm aware that we have taken a bit more time than we expected, and we would at least like to have 15 minutes to discuss with you as well. So I would briefly summarize my doctoral research, and Laura will do hers as well, and then we will open the floor for discussions. So in the context of my research, I looked at the role of international actors in influencing justice sector reforms in a country that emerged out of a conflict. So those of you who are not aware of East Timor is a small island state which is next to Indonesia, and East Timor redeclared its independence in 2002. And its colonial legacies go back to Portugal. And then after getting independence from Portugal, it was illegally occupied by Indonesia for about 20 years, and more than 20 years, with the UN coming over and letting a referendum for self-determination that eventually led to the independence of East Timor. So what happened in Timor was that after the redeclaration of independence, UN, and along with UN, many other international organizations such as the European Union, the bilateral agencies from the US, Australia, from China, from Japan, from Brazil, as well as from Portugal, got involved in reforming the justice sector. So what you have here is a picture of of a collaboration that Portugal has revived with East Timor in order to train their judges in the local judiciary. So the question that I asked in my research was a question about the role of international and local stakeholders in the transfer, adoption, and adaptation of standards. And the specific standards that I was looking at were international standards on judicial independence and anti-corruption. So as I mentioned to you earlier, this is not, of course, starting from a very black letter form of law, because the international standard on judicial independence is a soft law at best, because there is a convention which agrees on the basic principles on independent and impartial judiciary. With anti-corruption, there is a convention against corruption, but again, you can consider that as a soft law. In terms of my methodological framework, I use a socio-legal framework because I was interested in the question of how do you bring social change where the norms, attitudes, and behavior of officials are shifted by the adaptation of new norms and new reforms within the justice sector. And then I used methods such as semi-structured interviews with judicial actors, as well as internationals who were working with Timorese judges, prosecutors, and public defenders in the country, followed by field observations and focus groups. Laura, over to you.
Yeah, so my starting point in my research was my interest into the responsibilizing of global value change. So into this very new legal field on corporate social responsibility of multinational enterprises in global value change. My interest comes a bit from the fact that I'm Swiss, and Switzerland is home to many multinational corporations. And then my question was, well, with this very fast changing legal field, or at least normative field, because as in Sapna's case, a lot of those norms are not hard law norms, but what we call soft law norms or standards and regulations and multi-stakeholder initiatives. So I was interested in, well, how does actually a big corporation, a big multinational enterprise deal with all these new regulations emerging within just a couple of years within typically different states that are typically home state jurisdictions to multinational corporations. And then I was secondly interested in how do these new normative rules, how do these new norms affect, change, amend, define the local relationship between those corporations and communities that are impacted by the business activities of those corporations. These are a bit the questions I started my research with. As said before, with a background in anthropology, I went to Colombia and I lived in and around those coal mines of the corporation I was studying for a couple of months. And then I also later came back, so I went twice. And I just observed, I accompanied the people that were responsible for implementing new norms on human rights and the environment, climate change, etc., on the ground in those very local settings of coal mining in Colombia. And as also I said before, I chose transnational law actually as a methodological framework to look at these processes, because in the end I was interested in the impact of domestic norms, domestic laws adopted in global north jurisdictions, and their effect on the subject they actually want to regulate, which is a constellation in a global south jurisdiction. And so to me, this is why I wouldn't say this is transnational law, because obviously it's domestic norms, but domestic norms that should have an extraterritorial effect. And this is why I chose transnational law as the methodological framework to look at these processes.
Okay, so with that, we come to the end of the talk. Thank you all. You can definitely email us if you have any questions, or you can follow us on Twitter and messages there. But before that, we would like to know if you have any questions now, please feel free to ask us.
Thank you very much for that, Laura and Sapna. So if anyone has any questions, you can feel free to raise your hand and unmute your mic, or you can also use the chat function.
Any of you thinking about doing a research in the area of transnational law?
So while people are typing, because I know sometimes it takes a while to type, so it seems that you both disagree as to, well, I think that Sapna, you're saying transnational law is not a methodology in itself based on the red text in the slides, but Laura says it is. So why do you say it's not?
So from my perspective, transnational law is a theoretical framework, maybe not a methodological framework. And I agree that I come with this idea of when you talk about methodology, you immediately go back to the established disciplines in either sociology, established disciplines such as sociology or anthropology or political science, and that can become your methodological framework. And in contrast to that, if you talk about theoretical framework, which is basically how we understand the world. So for me, transnational law as a theoretical framework makes sense because with the lens of transnational law, you see that how actors who are situated across the borders of different nation states can influence norms and institutional arrangements in different parts of the world. So I think that's where we are disagreeing, because Laura takes the stance that even asking that question is a methodological stance, whereas I take the stance that it is more of a theoretical stance. Laura, if you want to...
Yeah, I think I put a lot of emphasis on the difference between methodology and methods. Because with methods, with Sapna and I, we totally agree, law doesn't give you a method on how to study the impact of law in society. The methods are chosen from other disciplines that are expert discipline in studying impacts of policy, for example, in society. I think we need a methodology as legal scholars to turn away from studying black letter law in court cases, in laws in general. And to do that, a theoretical framework is not enough, because a theoretical framework is on an abstract level, to my mind, whereas the methodological framework gives you an entry point into fitting in your theories about this topic, about this change, for example, about this legal change. It gives you the theory and it gives you the methods within that methodological frameworks. And I would say that transnational law not when Jessup defined transnational law as something in between the international, not in between, but something new that fills the void in between domestic and international. And this wasn't a methodological intervention, but with what scholars did after that, with this idea of transnational law, this is, to me, this is best described as a methodological framework.
Yeah, I think to maybe briefly summarize, as you might see from our slide on the actors, norms, and institutional arrangements or processes, as Zumbanson calls in his paper. So if you're following those sort of like lens to study about a transnational legal phenomenon in a local context, then that is maybe your methodological framework to look at this phenomenon, and that's perfectly fine, because it kind of helps you to analytically understand the intangible phenomenon that is existing out there. So I think, Laura, we do agree on like how do we go about it. Maybe what we are disagreeing is on the categories or like the terms that we use when we say, is it a methodology? Is it a theoretical framework? And then we build on different sets of scholars. So Laura builds on purely interdisciplinary legal scholars. I build on interdisciplinary legal scholars who have been strongly influenced by sociology and political science literature.
Okay, and I see we have... Go ahead, Laura.
Just to flag the disagreement that is going on between Sapna's and my research, this doesn't just come down to us, but this is a reflection of a disagreement or different perspectives within the field as such.
It's very interesting. I like that you're able to articulate these thoughts here, because I think transnational law is, well, I know it's not really an area that we have a lot of research output from the region, but as you may know, the Caribbean is really developing as a research output area. And the University of the West Indies is trying to really encourage greater research output, but it will take a while to get there. So this is why these research skills series are really useful. And I see we do have some of our master's students here today. So I have one more quick question, then I'll hand over to Justin, who has a question. So our master's students may not have had the exposure to any type of transnational study because we don't actually have the expertise. So let's say they're interested because they heard this and they think, oh, this is something I want to get into. What is one piece of reading, one piece that you'd recommend that they start with? And then I'll hand it over to Justin.
Emma, you might have to give us one each,
Yeah, so one each.
I would say get Halliday and Schaefer's 2015 book on theorizing transnational legal orders. It's openly available through Cambridge University Press, and they have it's an edited collection, so they bring around examples as well. Laura, over to you.
Well, I think I can agree with that choice. Just also to highlight, there is an Oxford Handbook on Transnational Law that was published last year. The editor is Zumbanson, and this is a collection of different essays on transnational law. I think if you could get that book, it's quite handy because the titles are very subject specific. So for example, you have an essay on transnational sports law, on transnational criminal law, and then you can read those essays based in your own interest, in your own background. I think this always eases the way into a new thinking about the law when at least the context of that new thinking is known to you.
All right, and I'm going to hand it over to Justin. And thank you, Sapna. I see you put the link in the chat. So Justin, you can ask your question.
Thanks, Emma, and thanks, Laura and Sapna, for that interesting presentation. So I've had limited interaction with transnational law, obviously, having gone to King's College London. That's where I've learned most of what I know about it. But my question is, if we don't agree about the norms at any level, does that compromise our ability to engage in any sort of debate about transnational law?
Mm-hmm. Justin, that's a very tricky question. It's similar to what Emma was also trying to push us through, I feel. Laura, shall I go first and then you go next?
Yeah.
So this is something that we have discussed amongst each other as well. Like, because our starting points are so different, because our theoretical frameworks are quite different, can we even constructively engage with each other? And within the academic field, we can distinctly see that scholars who follow Halliday and Schaeffer's mode of transnational legal ordering theory, they write for their edited collection, which is actually supported by the Cambridge University Press, and they follow their sort of prescribed way of doing transnational legal research. And then we see the other camp engaging with each other on how to study about transnational law and the issues that they look at. So far, we haven't seen a cross dialogue, although these authors do cite each other to a limited extent, but not very extensively. We can see that in the citations as well. There's only very limited reference to authors coming from these different camps. And Laura and I are hoping that we could collaborate with each other and try to come up with at least an article piece where we can engage with these debates in a more constructive way.
I was going to say that sounds like a perfect thing to discuss, both of you, to have a very interesting publication there.
Yes. And Emma, you are the reason, you're the catalyst for it, because we
Oh, well,
wouldn't.
thank you. I tried to, encourage others. But no, thank you both so much for today. I'm aware of the time, so I will end it here. But this was very informative. I think it's been very helpful to everyone who attended. As I said, we don't have a lot of transnational research coming out of the region. There might be some on it, but not necessarily from Caribbean researchers. So always very useful to us to learn from others so we can expand our research offering. And I hope that those master students whose names I am seeing found this very helpful. Perhaps we'll see some, master's dissertations, even PhDs coming out in the next few years in this area. So thank you very much to both of you for turning up today, for an excellent presentation, and for really teaching us about transnational law, the different views, and how you can go about researching, because we do focus on the skills in this series, and we love to hear how other people have approached their research and different things you need to take into consideration when conducting research. So thank you very much, and I look forward to seeing you both again, hopefully in person sometime soon.
Yes, thank you, Emma. Thank you, Justin.
Thanks a lot
Thank
for
you
having
all.
us.
Yes.
Bye. Thank you.
Bye.
And thank you everyone for attending.